Hello, all. Welcome to week 4 of legal aspects of kinesiology. This is our lecture video for chapter 6. So this week we're going to be looking at discrimination. So if you'll download the PowerPoint here, I have it already up and ready to go. So this PowerPoint is talking about employment law. So some of the topics here are going to affect discrimination in employment. Basically, some different areas of employee exposure and laws that affect it, especially employment specifically for sport managers. So things like employment discrimination, relevance to sexual harassment, and federal employee legislation will be highlighted. Again, I'm just going to go through some of the highlighted slides that have notes on them. So the first thing is just looking at an employment relationship. So the contract that exists between an employee and an employer, basically it has to be, there has to be a legal conflict must establish that an employment relationship exists. So there has to be a legal contract between the two. More on that. So contracts dictate when and why an employee must be fired. So an employee has to do something to break the contract in order for laws to go into effect against them. There's certain laws that protect employees, such as discrimination. We're going to kind of highlight. I'm going to scroll down to slide 13 that highlights discrimination. You read this a week ago in some of the notes. In fact, one of the case studies I think highlighted this as well. But the 1964 Civil Rights Act, Title VII. So this is basically protecting employees or any person who's employed at a facility from discrimination. So protected classes: race, color, national origin, gender, and religion. Those are the three big ones. So an employer cannot fire an employee just because they're a certain race or a certain color skin, or have an accent, or whether they're a man or a woman, or if they're Christian or Muslim or Sikh or whatever. So it protects us from being fired just because of our beliefs, right? Now, I would state that you have to be careful that you're not subjecting your beliefs or pressing them on others in a bullying or taunting way, because then that's where it gets kind of iffy, because just because I'm a Christian doesn't mean I can go around telling everybody except Jesus, or else they're going to fail in class. Obviously that's not right. I can't do that. But it does protect me from being able to express my faith openly and choose to pursue Jesus without risking me losing my job. Obviously, teaching for a Christian university helps in that area. Anyway, so treating employees or job applicants unequally on the basis of personal characteristic or trait is really what the law, what discrimination stands for or represents. And then, directly in employers, discriminatory words or actions towards an individual, it protects the employee from that. Disparate treatment. This is basically what dictates that discrimination take place. So it is the intentional discrimination. 3 things out of these 4 must be proven in order for disparate treatment discrimination to take place. So a member of a protected class applied and was qualified, was rejected by the employer, position remained open, or was filed by a person not in a protected class. This is kind of interesting. So in the hiring process, an employer cannot deny you the opportunity to qualify for a job just based off of your background. And this has been an issue, especially in higher education. I've seen this where I've seen when there's two very good applicants, so let's say for instance, I won't even talk about race, but let's just talk about gender. There tend to be, or used to be, there were less females working in higher education than there were men. And then if you add race to that, then it was always, predominated by white males, and then white females. So if a white male was qualified for a job, but some other race female applied for the job, if she was less qualified but got the job over the male just because of diversity, the school wanted to diversify, I've seen lawsuits happen because of that. So it's kind of interesting. Really what it comes down to is it shouldn't be about race or class or color or whatever, or gender. It should be about who's the most qualified to fulfill the position and help the principals or the students or the athletes involved. That's not always the case. So defenses, so used to justify discriminatory practice. Example is given like female locker room attendant, males are ineligible. So gender here, so fitness trainers at a single-sex health club, race being a factor as well. So obviously there's cases where men do not qualify to work with women in a locker room. Right? That's just frowned upon, right? Okay, so there are clauses for that. More about disparate impact, unintentional discrimination is basically what that's covering. Defense is business necessity, so how businesses can protect themselves, and then more on that. Then it gets down into disabilities. This is another act, the Americans with Disabilities Act, so ADA, of 1990, the year I was born. So what is this about? Basically, this is protecting people with disabilities. So similar discrimination, but focusing on those who have a disability of some sort. So there has to be accommodation for the worker and the individual. The next thing is sexual harassment. So elements of sexual harassment, so unwelcome sexual advances, not desired by the employee who becomes a victim, who is the victim, conduct that creates a hostile or abusive work environment, and then can arise from either verbal or physical conduct. So check out Title 7 that we looked at earlier. There's a section of that Discrimination Act that sexual harassment falls within. Quid pro quo is basically equals something in exchange for something else. So a sexual favor demanded for raises or promotions, basically a hostile work environment. This is a big no-no. You can't sleep your way to the top, so to say. That's very frowned upon in today's society in general. And then a couple employment laws. There's COBRA, HIPAA, and FMLA. HIPAA's a big one recently. Basically, it's prohibiting exclusion from medical coverage and medical record confidentiality. This one's fascinating to me because of the whole pandemic that occurred and the requirements for vaccinations. Can they actually ask you for your medical history, and does that determine whether or not you can wear a mask or be free from a mask? So things like that are protected through HIPAA. A couple other big ones: Fair Labor Laws, Standards Act, obviously frowning upon child labor, how much overtime and minimum wage. Civil Rights Act of 1964, that's the Discrimination Act that we looked at. ADEA, which is the age discrimination for employment, and then the disability one, which is ADA. So as you're reading through your text, take a look at these different employment laws and become familiar with them. Okay. All right, that's the chapter reading for this week. Make sure, again, you get the quiz done by Sunday and dive into the reflection. Again, this reflection assignment has some questions for you to address, and actually highlights the Discrimination Act on the first question. So make sure you get that post in by Thursday and respond to 2 peers by Saturday. All right, talk to you all soon. Bye.